Well, welcome everyone to this edition, this July edition of our England and Wales Property Forum, led by Ian Quayle and hosted by Stewart Title, where we'll be discussing the topics that you want to talk about. We do not have any guest speakers today, so it's now fully open for you to lead the conversation in a direction of your choosing. And we have a few questions that have already been submitted, so that should get us off nicely. I'll be working the background as usual, so if anyone wants the mic, please raise your hand. But as usual, just put any questions or contribute to the sidebar and the chat section. We're going to see if everyone can hear me. Stewart Title will be sending out dates and information about the face-to-face meetings that Ian Quayle is going to be doing, and also his back to basics conveyancing problems that he'll also be holding, and we'll send out all the dates after this. We've found that people are a little bit more optimistic recently, and that's converted into more work. So we're hoping that you're seeing this as well, especially sort of post-election fever. And Ian's obviously going to be talking a little bit more about how that's affecting everyone and how the new rules and regulations might be changing the game. But thank you very much, Ian. Over to you.
Thanks very much, Freddie. As usual, it's lovely to speak to you. Massive thank you to Stewart Title, Freddie, Ted, Robert Kelly, Stephen Smith and the team. Really do a lot of work with Stewart Title. It's a delight to work with the team because A, they're really nice people, and B, they've got some really good products and they're good company. And again, those of you that aren't using Stewart Title in connection with title indemnity insurance, please have a chat with Freddie and the team about your requirements and needs. Have a look at the website and just see how they can help you. Again, they're not pushy by way of sales, etc., but are there to assist the profession. And I think inviting me along to put my 2 pence in every now and again is an indicator of their willingness to support the profession, sort of indirectly, as well as providing product. So if you can, have a look at the website. Freddie, I'm sure that you're happy to talk to people virtually, face-to-face, or via the telephone with regard to needs and requirements. The beautiful thing about Freddie and the team is that they can pivot and can come up with product, etc., depending on needs and demands. If there's a market for a product, they will look at it. If there's a problem, again, they'll explore it. So that's well worth bearing in mind as well. So thanks again, Freddie, for the introduction. Remember, this is your event. And remember that you can post any questions that you like in the chat facility. As Freddie mentions, if we can get your microphone on so that you can talk to me if you wish. But we've got a lot of topics to talk about today. Unfortunately, or fortunately, all BSA related. That's fortunate for me because that's my bag. Unfortunately for you, because it's a bit of a dry subject. But we've got quite a lot of questions that people have posted about the BSA, which I'll deal with. Just as I always do, useful websites. All of these sites are useful. Some of them are free to access. If you haven't had a look at the Leasehold Advisory Service website, do. It's important in connection with leasehold work. Leasehold Knowledge Partnership, also important, very sort of political, to be honest with you, but very sort of supportive of leaseholders. I mentioned at the bottom of this slide, Property Law UK. Michelle, if you've got problems with regard to hearing, I think everyone else can hear. So what I suggest, Michelle, is if you log out and log back in again, that might help. If not, we are recording the event, and I'm sure we can get a recording available to you. But yeah, thanks very much, everyone. So meanwhile, Property Law UK, sponsored by Stewart Title, a monthly publication. And to be honest with you, I was just talking to the team this morning. I am immensely proud of the content that is generated each month. Case reports, articles that are relevant to commercial property lawyers and to residential conveyancers, a wealth of very experienced, very knowledgeable editors and contributors that send out information to us that comes to you in electronic format on a monthly basis. meaning that if anyone visits you and asks you about your competence with regard to conveyancing and asks you what to do in connection with keeping up to date relating to conveyancing, a subscription to Property Law UK, I think, is a perfect indicator of this is what we do to keep up to date. It's not for me to be critical of other publications, but I have and continue to subscribe to the Estates Gazette. I've done it for years. And every month and every week I complain about the lack of sort of case reports or the lack of meaningful articles for residential conveyancers. Quite a bit in for commercial property lawyers, but we're trying to address the balance. If you're interested, there's going to be a Building Safety Act special edition that comes out probably this Friday, if not sometime next week, that's free. If you want details of subscriptions, let me know. If you do subscribe as a firm in July, I think the first 3 firms that subscribe get a free copy of, you've guessed it, the Building Safety Act. Freddie, I notice you haven't bought a copy yet. Thrilling bedtime reading, it has to be said. Again, on a serious note, the number of people that come to me and say we've bought it and it's an absolute Bible. So it's rather embarrassing, really, as to the positivity that the book generates. So if you subscribe to Property Law UK as a firm, first 3 firms that do that get a free copy of the book, which is worth £125. Zara is boasting about getting a signed copy. Zara, always my pleasure to meet you. Lovely to see you in Bristol last week at a face-to-face conference. Before I go any further, Freddie mentioned we are organising face-to-face conferences that Stewart Title sponsor up and down the countryside. And we've got a Back to Basics series of webinars that Stewart Title is sponsoring as well. So again, on the Stewart Title website, there's information about all those events, which, as I say, are very popular, very well attended, and we get great feedback from. Michelle, I'm assuming that everything's all right now with regard to your ability to hear. So we'll push on. Topics that I wanted to talk about. First of all, and Zara's banned from answering the questions concerning the TA6 and the Law Society's position. All I want to do, kidding Zara, is ask the question, first of all, who is using the revised TA6 form? Anyone using it at the moment, and what sort of feedback are you getting from clients? What sort of issues are you having? Anyone sort of with positive feedback about the revised TA6? In other words, we're using it, and despite Zara's funny emoji, we're happy with it. Amanda, not using it. Nicola, not using it, seeing roughly 2 to 3 per week on purchase matters. Really, Nicola? Joe, not using it. Nicola, can I ask you a question, please? How are you finding it in sort of combat, as it were? So you're acting on behalf of buyers. Have you revised your retainer? And how are you telling buyer clients to view the content of the questions? Not that bad, but does generate more additional inquiries. Okay. Are you talking about more inquiries that you're generating, or are you talking about the buyer client saying, hey, what's all this about? Rebecca, not yet. Very few seen in transactions. So, Nicola, I'm going to pick on you for a moment. Kate, thank you as well. Longer to check, more we raise because the replies aren't great, etc. Yeah. But Nicola, have you had a buyer client saying, oh, this is good? Or have you had a buyer client saying, crikey, this is a bit confusing? I'm conscious for everyone, Kate, I'm going to come back to you, that the new TA6, the revised TA6, if I can call it that, I think requires more input from you. And therefore, I'm interested, are you charging more for the work that you're doing? So Nicola's saying, not sure clients have read it. Yeah, hey, that's my sort of stamp. Kate, using it, haven't seen much change so far, but only recent. So when you say recent, what do you mean, Kate? And again, have you revised your retainer to make sure clients are aware of the new format? And anyone who's encountered it when you're selling, have you, and I'm very interested in this because I'm doing some work on it, are you advising or explaining to the client, A, their potential vulnerability for misrepresentation, B, the consequences of some of the questions, and has anyone had a situation where a client seller has asked for guidance, as the revised TA6 requires, in circumstances where they don't understand how to answer the question? Michelle, hi Michelle. If we have to use it, we intend to charge more and offer help to clients to complete it. Yeah, I think Michelle and Kate, I would like you to be careful about the retainer, because if you look at the TA forms and the warning on the TA forms about the client being required to complete them forms themselves and about the potential for liability, what worries me is if we intervene and provide assistance in connection and help to complete the forms, are we not potentially generating risk with regard to the client getting it wrong, or we getting our advice or assistance wrong? Now, I'm talking to insurers about this at the moment just to see. I think there's some wording that we can use in the retainer that reduces, I'm not saying eliminates, reduces the risk with regard to a seller being sued for misrepresentation and then either joining us in proceedings or suing us and us being liable. Zara, I knew you'd say this. Law Society have got it wrong. Yeah. Tech is available. I get all of that. Zara, I'll come back to it. Solicitors being required to check what estate agents and clients are saying before instructions is a problem. Michelle, we're intending on pre-populating some replies and to get them to sign a disclaimer. That's an interesting approach, Michelle. From a seller, yeah, great point. Nicola, from a buyer's perspective, it's great. From a seller's perspective, not so great, even though it's still doesn't cover things a buyer'd want to know. Electrical vehicle charging points nigh on useless, yeah. Mobile signal issues, yeah. It is nonsense. I think it needs refining, doesn't it? And I think, as Zara says, you know, the Law Society has got it wrong, and trying to redeem themselves isn't helping. Hi, Mark. Yeah. Well, Mark, this is the point. I think there's a fine line to tread. So I think we can provide information and explanation as long as the client understands that ultimately the answer is the seller's answer and that they could potentially be liable for misrepresentation. I think the other point is, Mark, and again, you touch on this, I think there is a duty on you as the seller's solicitor or conveyancer to check what the seller says against the information on your file, but to make sure the client understands that's all you're doing. Yeah. Quality, yeah. Well, Zara, we come on to TA7 forms. I hope we'd missed this, but TA7 forms are a nightmare. Yeah, I think that's the point, Nicola. Right? Have you seen the judgment in? Oh gosh, the one I always go on about the window. What the judge said there is this idea about a seller being in a perfect position to provide information to the buyer and the seller's duty, courtesy of the TA forms, to share that information. Gosh, what's the name? Eludes me. Rosser and Pacifico. There you go. I'm not round the bend yet. Have a look at Rosser and Pacifico, right? And in it, the judge is saying a seller is required to provide this information because the seller is likely to be more aware of the answers to the questions that a buyer is likely to generate. It's quite an interesting judgment. So, Nicola, you're saying, yeah, complete an information form comprising lots of stuff, but are you saying lawyers shouldn't get involved, or are we saying there should be a sort of general exclusion that we can't be liable if we make a genuine error with regard to a reply, and that if we deliberately lie, there's liability for misrepresentation, but nothing else? Perhaps that might be the way forward. But hey, look, it's not for us, is it, to get involved in that? Yeah, Joe. So then what do you do? If the sellers refuse to sign the declaration, you know, what's the value? The point I would make, Joe, is that if a seller didn't sign the form, but drafted the replies to the form, I think the seller could still be liable for misrepresentation and definitely could commit a criminal offence under section 2 of the Fraud Act if they deliberately lied with regard to a response. Zara, we can qualify, do not allow us to qualify the replies. Qualification is possible, Zara. The not so far as the seller is aware type of response is dangerous. We're all familiar with William Sindel PLC against Cambridgeshire County Council. And again, have a look at Rosser and Pacifico with regard to a requirement, if you're answering a question, to undertake reasonable investigations before answering it. Has everyone seen Rosser and Pacifico and the webinars I've done on the TA6 and TA7 forms? Anyone not seen them? If you haven't, I'll try and get a recording available for people. Yeah, Nicola, again, it is raising more inquiries. And there's previous case law, again, that I've talked about in the past that says if you have a wide-ranging question, that warrants a wide-ranging answer. So if, for example, well, Amanda, drop me a note by email. I'll get it across to you, because I've done a few webinars on the TA6 and TA7 for different people. I'm sure we'll have a recording for you. Zara, yeah, the Law Society is saying seller won't have to answer by using digit, but if the first bit's answered correctly, you won't get the remaining relevant one. Yeah, I mean, again, that's the mess I don't like. The idea with regard to part 1s and part 2s, and what's our role with regard to part 1s. As I say in the recording, Amanda, I described the new revised TA6 as sort of creating a mist or a fog as to what we do. Okay, so what can we conclude about this then? We're seeing revised TA6s. We're seeing problems with regard to clients not completing the declaration or refusing to sign the declaration. We're seeing a situation where we've got incorrectly completed TA7 forms. Again, I've got some guidance notes as to the information that you provide to the seller when completing revised TA7s. Happy to do that. Mark's quite right about what we do with regard to clients. I've hopefully explained that. Yeah, the fact, as Nicola mentions, there are questions that should be raised and aren't. Again, with regard to the TA7, Nicola, there's loads of questions about when the leaseholder notified the landlord of their intention to sell. What was the date, if appropriate, where the landlord requested a leaseholder deed of certificate? What was the date, if appropriate, where a leaseholder demanded or asked for a landlord certificate? So there's problems with regard to the TA7 as well. Right. So we'll leave that then. I think we can say, yeah, Nicola, the TA7 form is crazy. Have you got, Nicola, my notes, my information sheet for the seller client about the TA7? I think people say that helps. Because in it, what I do is I explain what remediation work is, or how you could explain what remediation work is. Yeah, Zara, just ping me an email and we'll get it across to you. I also explain to the client what a landlord certificate is, what a leaseholder deed of certificate is, and also explain the likelihood that we're going to be asked questions about dates of requests, etc. And it also includes what we should be doing by way of disclaimer. So yeah, Zara, happy to send it to everyone else. I'm working on some notes with regard to the revised TA6 form, but I haven't finished it yet, and it's, to be honest, taking quite a bit of time. Okay, right, let's leave that, and yeah, happy to send anyone a copy of what I've done. Next thing, I'm going to talk about mines and minerals, and I want you to refer you to a case that was reported. I've just criticised the Estates Gazette, and I'm now going to refer to a case that was in the Estates Gazette. A case called Cleveland Potash against Drummond and others. Has anyone seen it? 2024 decision, High Court decision concerning reservation of mines and minerals and what it means. And put simply, the phrase mines and minerals, according to the High Court, is not a definitive term, but is capable of bearing a wide range of meanings. Unless the meaning is clear from the instrument itself, the court must ascertain what the phrase means in the vernacular of the mining world, the commercial world, and landowners at the time of the grant. Meaning may be determined by direct evidence or by inferences drawn from the court. Really interesting case. I've done a case report on this in Property Law UK, because although it's sort of a commercial case, a commercial mining case, it's interesting in helping what is meant by mines and minerals and attempting to decipher what mines and minerals actually mean. Anyone read it? Anyone seen it? Anyone had any problems with mines and minerals? A question I'm often asked about mines and minerals is that if mines and minerals are excluded from a title but not registered, do they still belong to someone else? And the answer is there's no need to there's no obligation to compulsory register mines and minerals. You can register them, but there's no obligation to. Just because mines and minerals are registered is not necessarily an indicator that someone is intent on carrying out extraction of mines and minerals. Some bodies have just registered mines and minerals because they can. Being this ever sceptical so-and-so that I am, I think the Land Registry allowed mines and minerals to be registered because in the last recession, was it 2008, the Land Registry was looking for work to do and decided that the registration of mines and minerals might generate work for them. Interesting point on mines and minerals, didn't know if you know this, but you can claim adverse possession of mines and minerals. There's also a theory that you can claim adverse possession of airspace. As residential conveyancers, in your retainer, always explain whether or not you're going to be giving advice about subterranean ownership and airspace ownership. In a commercial context, important. In a resi context, you're perfectly entitled to say, I won't be giving any advice relating to it unless you tell me that you'll be undertaking some form of activity that will involve subterranean activity, excavating gardens, excavating underground garages, etc., or airspace development. Mark, very common entry in Derbyshire and Nottinghamshire. Yeah, it is. Local solicitors don't bat an eyelid. Well, yeah, fine. But it becomes an issue, doesn't it? If your client undertakes an extension, has to put in some form of pile foundations because of ground conditions, but doesn't own mines and minerals beneath it, then that activity could constitute a trespass. And I don't know if you're aware of it, but there was a case, I think, in the Northwest where I think it was the church commissioners brought proceedings seeking an injunction against a developer on the basis that the developer was putting in pile foundations that trespassed on the mines and minerals that the church commissioners owned. Yeah, Mark, I think that's a wise thing to do. Okay, deep excavations, swimming pools or cellars, so the client is aware that, hey, in the normal course of events, we're not giving advice on these issues. Michelle, so many people are asking for indemnity policies, even where the register clearly sets out the rights are accepted. Yeah. Do we explain, Mark, that what ownership of the surface actually means? Well, Zara, how likely is it that someone will come along to dig up a developed area? Unlikely, but I'm not worried about extraction, Zara. I'm worried about a landowner becoming aware of subterranean activity by our client and getting into difficulty as a result. Now, again, Zara, I'm going to concede that it's highly unlikely, that a mineral or mines owner is going to become aware of subterranean activity that we participate in. But as I say, I have seen one case where a developer got caught out. So, Zara, I think you're right. From a risk perspective, not high. Yeah, Claire, that's a good point, isn't it? Extortion rather than extraction. Like it a lot. Great point. Any other comments on mines and minerals? Were you aware of this adverse possession point relating to mines and minerals? And I'll tell you something, talking about adverse possession, is everyone aware that it's possible to claim adverse possession for a rent charge or even an estate rent charge that's not been collected? I've read about that and done a bit of research on it. I've never seen anyone. You did. Nicola, have you heard of anyone actually making the application? That's the thing that really interests me. Because it would be useful, wouldn't it, if there was an estate rent charge that hasn't been demanded for 12 years or 10 years or whatever, that you apply for adverse possession and extinguish it as a result. Oh, that's nice, Zara. Yeah. Nicola, I have no idea who told you about it. Might be some strange character from up north, you never know. Zara, trying to sell me land that's sitting on that's legally registered to someone else. That's an interesting one, Zara. Explain that to me, how they're getting away with that, if you can. While I'm waiting for Zara on that point, determined boundary applications. Hey, folks, yet another case to talk to you about. Really interesting one, this. I'll just pull it up on my other machine. Again, I've written a report on this. Holder Vale against Holdaway. Anyone seen this one? Right, okay, Zara, yeah. Holder Vale against Holdaway. Have you seen this 2024 decision? Interesting thing about this, determined boundary application made to the land registry. Neighbouring landowner objects. Off we go, skipping to the first tier tribunal. First tier tribunal determining. All right, Zara, you've got a boundary problem as well. Okay, nice. Sounds like a really interesting one. So Holder Vale against Holdaway, determined boundary application, objection, parties can't agree anything. We go skipping off to the first tier tribunal. First tier tribunal says we cannot determine the boundary because we've got no evidence to say where the legal boundary sits. The applicant says, if you look at the transfer to us, the line on the plan annexed to the transfer clearly identifies the legal boundary. And the first tier tribunal says, no, it doesn't. Okay. The next thing is that the TR1 form in the description of the land being transferred describes it with a description, a sort of postal address, and then says it's shown edged red on the plan annexed. Okay, so in essence, with regard to the determined boundary application, tribunal says, sorry, we can't fix the legal boundary because we've got no evidence to say where the boundary is. That was interesting, but the point I want to make to you that I think is really interesting is this. The first tier tribunal explains the process to locate a legal boundary. And this is really a repeat of the Pennock and Hodgson 2010 Court of Appeal decision, which I'm sure you're all familiar with. If you're not, have a look at it because it tells you how to identify legal boundaries. So tribunal says, extracting the principles from Pennock and Hodgson, 1, look at the words or parcel clauses first and see if that describes the land in question in the transfer. So that goes back to Lord Justice Mummery in Pennock, who says the same thing. Ignore the plan, look at the words. The judge in this recent case says, where the words are clear and specific and sufficiently identify the land in question, then forget about the plan. If the words aren't sufficiently defined or refined, then even if the words defer to the plan or otherwise, it's necessary to look to the plan to see if the boundary in question can be ascertained clearly. If the plan is sufficiently clear and unambiguous, again, no further steps are necessary and extrinsic evidence not necessary. Where wording or the plan are ambiguous or vague, then, said the tribunal, the following steps need to be taken. And what the court said is you follow the tests identified by Lord Justice Mummery in Pennock. And put simply, what he said was, have a look at documents that were contemporaneous to the transfer or conveyance that is attempting to be deciphered. So have a look if there's anything that was created at the same time as the conveyance or transfer that reveals what was intended when the boundary was created. Where there is wording that's used and there is evidence from third parties, witness statements, declarations, anything else that, again, leads us to be able to indicate what the parties intended, rely on that. But the important point here is, and again, it's not rocket science, if you make a determined boundary application and you submit to the land registry a conveyance, a transfer, and a plan annexed to it, you're not going to get a determined boundary. The land registry require a plan that is Practice Guide 40 compliant, that clearly indicates the location of a boundary. In other words, a larger scale plan, or reference to something like national grid coordinates. If you're creating new boundaries, or you've got a problem like Zara has, it might be beneficial to sort of peg out where we think the boundary is and take photographs of what we've done with pegs or with white stakes, etc. I think I've mentioned to you before, I've seen disputes where a site's been pegged out and then the parties have fallen out because the question is, where on the peg or where on the stake is the boundary? Is it the centre point? Is it the western face of the stake or the eastern face of the stake? I mean, it's ridiculous, isn't it? But that's the state of play. Anyone made a determined boundary application? I continue to bleat on about this. Brilliant where there's agreement between neighbours. Nightmare where there isn't. But a determined boundary gives you a legal boundary noted on the relevant titles, meaning that there can be no argument or dispute going forward as to where the boundary actually sits. Yesterday I did a webinar on highways. And again, be careful where you're worried about ransom strips. Highway authority plans are notoriously unreliable. There is an inquiry you can make of the highway authority that requires them to carry out investigations and undertake a site visit to try and get more precision with regard to a highway boundary. But do be careful. And the other thing that came out yesterday, which is interesting, well, put it to the room. If you're acting for me and I'm buying a property that abuts a public highway, how many people here would advise me about my obligations with regard to tree management, with regard to flooding of the highway, and a failure to keep ditches running the line alongside the highway, yet within my title, kept clear and cleansed? Does anyone do that? So I'm buying, no, but again, Zara, the point here is that if there are trees on my land that are diseased or run a risk of falling because of their state and condition, then I'm potentially liable if anyone sustains injury as a consequence of that tree falling. I can't be liable if I undertake a reasonable investigation on the trees on my land and confirm that they don't appear to be diseased or in any way, shape or form dangerous. Nor can I be held liable if I have a healthy tree on my land that, due to storm, heavy rain, etc., collapses and falls onto the highway, causing death or injury. As with regard to flooding, I can't be liable if water on my land flows down onto the highway as sort of normal drainage. But where I build ponds, where I divert streams or ditches on my land that causes flooding on the highway, I can be liable for it. And if there is soil or dirt falling from my land onto the highway as a consequence of activity that I'm undertaking or having undertaken on my land, I can be liable for it. So again, Zara's saying she doesn't deal with that. Mark, what about you? Nicola? To be honest, it wasn't something I thought about that much till I was talking about it yesterday. And I'm thinking, well, hang on a minute. You know, if I'm a landowner, it's going to be important, isn't it? Could be Zara, yeah. Could be. A highway authority can inspect the trees that are on your land and can compel you to take action, and if you don't, the highway authority can do it. And if there's a ditch on your land that's not kept clean and free of rubbish, then the highway authority can do it. So Nicola, you do that, yeah. I think that's what most people do, but I hadn't thought about the tree issue. And again, with dreaded climate change and all that goes with it, you know, what are the risks? Well, the clearly risks are getting greater. It's funny I mention all that, you know, because there's a lovely laburnum tree in our garden, front garden, beautiful tree, and about a month ago, it just tilted and fell. And the reason it tilted and fell wasn't wind, it was rain falling on the canopy, and it just overbalanced the tree and down it came. So there you had a really healthy tree that just fell, not as I say, due to storm damage or wind damage. Yeah, you've had it as well, Nicola. Yeah. So, you know, if that was on a highway and it caused an accident, well, in that circumstance, I couldn't be liable. But if the tree was damaged, I could be. And if I hadn't got evidence that I inspected the tree or had someone inspected the trees on my land, that could be a problem, couldn't it? I hate doing this, you know, because all I seem to be doing is highlighting further things that we report to the client on. And I just think, I think it's quite simply in a report or in a retainer or in an information sheet. It's just a line or two, isn't it? So I'm not asking for an essay to be given to the client about trees, but I'm just saying, hey, I think we've got to warn the client about it. Okay, last thing on my list is professional indemnity insurance. I've been talking to insurers, and insurers are saying to me, hey, Ian, there's some good news. More insurers are prepared to insure conveyancers. The market is sort of softening, so spread the word. Then I was talking to someone at a conference, and they said they were having huge problems getting professional indemnity insurance as a sort of consultant conveyancing solicitor. Now, I think the lady that I was talking to was sort of a new business, and I wondered whether it was that. But the message I'm getting from insurers is, you know, we're a lot happier with conveyancers than we've ever been, to be honest. I don't know what everyone else is thinking on that one. And while we're waiting for answers on that, new business. Again, speaking at conferences, etc. recently, and talking to the profession generally and looking at my workload, I think people are busy. I was talking to someone today who was saying that their data, and this was a search provider, was showing that search numbers are well down at the moment. And they're saying, A, that's weather related, and B, it could be election related, and C, it's holidays. So what does everyone think about work? Zara, I'm going to have a look at that. Actually, if you send it via email, I'll dig it out when we finish. I don't have time to look at it at the moment. So what do people think about business? Are you busy? Do you think you've slipped a bit? Michelle, so right, it's a sort of client you've got. Yeah. You're extremely busy, but you've had a problem with your insurers. So what do you do there, Michelle? Do you just say, right, we're going to limit the number of people that we'll act for who are resident abroad? Yeah, Mark, good to hear. Derbyshire. Nicola, yeah, BSA related work. Joe. Zara's not doing BSA stuff. Yeah, okay, I get that. Michelle, I have heard of firms saying we're interested in the percentage of work that, say, is high risk. And Sarah, hi Sarah, new construction's flooding in Bristol, yeah. Do you think more people are doing BSA related work? Or do you still finding that firms are just not touching it and therefore there's a sort of ready stream? And are you, those of you that are really busy, are you finding that you can charge more for the work that you're doing? Yeah, I think there's still lots of firms not doing BSA work, Nicola. Zara, I'm fairly sure there's a lot of work being done. We're going to talk about BSA in a moment. Yeah, Joe. Yeah, I agree with that. I agree with that. So to be honest, you know, the Law Society guidance on the BSA, I don't think has achieved anything. Do you, Rebecca? Joe? In fact, if anything, I think they probably scared more people off. Just as an update, the Law Society guidance on climate change was due out in June. It's backed up now, and I'm told the latest smart money is it's going to be released in October, but this is going to be specific climate change advice for conveyancers. Sarah, no one's queried the work. So the message is getting through then, isn't it, Sarah, about increasing fees? And why not? And again, I go back to what we were saying about the TA6 form and the revised TA7. If we're doing more work, then we've got to, surely we've got to charge for it if we can. Right. Let's just have a look. Michelle, our percentage was less than 1%. We can't do it again at the requirement of indemnity insurers. Yeah. Michelle, if you do encounter a problem, let me know, because I do have a hotline into insurers. Yeah, another £1,000 for BSA related work. Yeah, I agree. But again, in Sarah's defense, it depends on market conditions, doesn't it? And also where you're getting your work from. Okay, well, talking about the Building Safety Act, my favorite subject, a number of questions have come in. So let's deal with them. First of all, have a look at this, everyone. And let's have a think about how we answer it. How do we answer this? Over 11 metres, freehold owned by a residence company. Not all residents participate in the acquisition of the freehold, therefore not shareholders. Separate management company, all residents are required to become a member of the management company. Seller is not a shareholder in the residence company. Would this qualify within the scope of the BSA, or would this be exempt due to the fact the freehold is owned by a residence company, even though not all property owners are shareholders? Well, let's look at the relevant law. And once again, I'm going to look at Freddie's favourite book, The Building Safety Act, with these characters, Butler and Quayle. Don't know who they are. Sounds like an interesting firm of dentists, doesn't it? Anyway, if we look at section 117 of the BSA, it defines a relevant building, at least 11 metres high or has at least 5 stories. So we're potentially a relevant building. But then what we've got to do is we've got to look at section 117.3 that says the definition of a relevant building does not include a self-contained building or self-contained part in relation to which a right under Part 1 of the Landlord and Tenant Act 87 or Part 3 of the Act, tenant's right of first refusal or compulsory acquisition by tenant of landlord's interest has been exercised. So we'd first of all have to investigate the acquisition of the freehold. Was it an acquisition under Part 1 or Part 3 of the 87 Act? In relation to which the right to collective enfranchisement has been exercised. So it's not included as a relevant building if we have collectively enfranchised. Or if the freehold estate in the building or part of the building is leaseholder owned, or it's on common hold land. When we talk about leaseholder owned, everybody, we've got to look at the 711 regulations and regulation 2. A freehold estate is leaseholder owned where the freehold estate is owned solely by tenants in the building, whether through a corporate structure or otherwise, and A, B, and D of section 117.3 do not apply. So, if we look at that, if the freehold estate is solely owned by tenants in the building, it doesn't say that all tenants within the building have to own, but it has to be solely owned by tenants. So I think the building is exempt. Zara seems to agree. Nicola is on our team too. Thank you, Nicola. Anybody else? Now I'm going to throw a spanner in the works because the Act and the regulations states owned by tenants, plural, but, and I forget where it is, there's somewhere else that says tenant owned. not tenants owned. So we've got singular and plural. And the problem that I'm fighting with in connection with two buildings at the moment is we've got two blocks of flats, all potentially relevant, both but rather potentially relevant buildings, but with one leaseholder in the block owning the freehold. And on a proper interpretation of the Act, the regulations and the notes, that one freehold owner means the building is exempt from being a relevant building, meaning that all the leaseholders in that building cannot have the protection of Schedule 8 of the Building Safety Act, the limitations with regard to the transmission of remediation costs for relevant defects into service charge. So hopefully that answers that question. Now, we've had another question this morning that I want to just refer you to. So I'm going to have a look at my notes if I can find them. First question, how are people currently finding the process of issuing landlord certificates? So it's a landlord certificate. And is this you, Meadow? Yeah, it is, Meadow. Hi. Including meeting deadlines and dealing with circumstances not raised by the legislation, such as multiple relevant defects with different parties responsible, and what constitutes becoming aware of a relevant defect as a trigger to produce a certificate. Got them. Okay, Meadow. Right, so this first question, the process of issuing landlord certificates. Can I start the ball rolling, Meadow? Right. Firstly, I'm doing a lot of work for a number of landlords who are getting requests for landlord certificates, either as a consequence of being notified of a leaseholder's intention to sell, or leaseholders directly requesting a landlord certificate. And immediately we're on the clock for 4 weeks. We can't ask for an extension of time, but a leaseholder cannot compel us to produce a landlord certificate. Okay, so what we're doing is looking at the leaseholder deed of certificate, if a leaseholder deed of certificate is served on us, and if the leaseholder deed of certificate is defective, we're indicating to the leaseholder that it's defective, not telling them why, asking them to reissue correctly, and then what we're doing is holding off until we've got all the information to produce a landlord certificate. Then we indicate to the leaseholder what's wrong with the leaseholder deed of certificate. We ask them to serve again, and then we serve a landlord certificate within time. Meadow, I've got some landlords that just can't issue landlord certificates in time and are just saying, look, we can't do it. I've got other landlords that are saying we won't issue a landlord certificate because the information you're asking for is commercially sensitive. And in those cases, the landlord is just taking the hit in connection with pre-existing relevant defects that require remediation. The interesting question you raise is about multiple relevant defects, and this is an important point, Meadow. Just because I've failed to serve a landlord certificate within the time limit prescribed after a trigger event does not mean I'm permanently liable for all remediation costs for relevant defects. If I discover another relevant defect that requires remediation after I should have served a landlord certificate, if the remediation work predates the certificate, then I've had it, I've got to be liable for it. But if I can prove that the remediation work or my knowledge of the remediation work postdates the date I should have produced a landlord certificate, I can issue a new landlord certificate. So the point is, and I think what you need to advise buyer clients is, although the landlord has failed to serve a landlord certificate within the prescribed period, this will not preclude the landlord from serving a new landlord certificate where it discovers remediation work for relevant defects. And it doesn't matter when the defect arose. The issue is, when did the landlord discover it or become aware of it? So that's the first question. Zara, I'm looking at your question there, and I'll come back to it. So what does everybody else think? That's my comment about landlord certificates. Anyone else got any comments about that? Yeah, well, that's the point, Nicola. If I'm a landlord, right, my advice to a landlord is, for God's sake, don't have a survey carried out. Right? Don't do it, because if you find out you've got remediation work for relevant defects and then someone asks you for a leaseholder deed of certificate, sorry, a landlord certificate, you've got a problem. Because if you don't issue your landlord certificate in time, you're on the hook for that defect. Whereas if you don't know it and you don't serve your landlord certificate and you become aware of it afterwards, you can issue a new certificate. So that's the point. Yeah, potentially, Zara, if we've got a deliberate lie, as Nicola points out. So, Meadow, your next question, let's just have a look at that. Do people think that a landlord requalifies to charge by issuing a landlord certificate for new defects, or even though it's failed to issue one within relevant time? Yeah, I do. So I think a landlord can do that. Does everyone agree? Just because I've failed to issue a landlord certificate when triggered to do so, that will not preclude me from issuing a new landlord certificate in the future. So what I'm saying to landlords is, look, if you want to properly manage your building, get a survey of the building done, okay? And if there's work that needs doing, issue a landlord certificate and transmit cost into service charge. And use that information that you've got. Make sure you've got accountancy information so that if someone requests a landlord certificate, you can produce it. Zara, I've no doubt in my mind that the costs of management under the Building Safety Act will increase service charge costs for relevant buildings and indeed higher risk buildings as well. Okay, Meadow's next point. There's a theory that leaseholders could obtain qualifying lease status by the back door as a result of a landlord not completing a landlord certificate properly within the deadline, and a person who didn't previously would not usually have a qualifying lease being deemed to have one as a result of the failure to properly complete, not completing with a timescale, a landlord certificate. That's correct. But could this apply to leases granted after the 14th of February 2022? Well, I think the answer to that question is that I don't think it does apply to leases granted after the 14th of February 2022. Because the point there is you can't have a deemed qualifying lease in circumstances where the lease cannot ever be qualifying. And if a lease is granted after the 14th of February 2022, it can never be a qualifying lease. Nicola, you agree with that, don't you? Meadow, do you get that point? But there is another point, Meadow, that does help you here. Remember that Schedule 8, Part 2 of the Building Safety Act means that a landlord can never transmit remediation costs for relevant defects where the landlord or an associate of the landlord was responsible for the original work that now requires remediation. Meadow, there's no doubt about it is a loophole in the legislation, but what government says, Meadow, is that if you've got a lease that's granted after the 14th of February 2022, and I disagree with this premise, by the way, but if that's the case, the building will have been built, or the work undertaken to the building would have been done under the new building control regime, which means there shouldn't be fire safety risks. The problem I get with that, Meadow, is that I've seen a building where all the works were done prior to the new building regs, but then the landlord didn't do anything with the building, just mothballed it, and now he's granting leases. So the leases are granted after the 14th of February 2022, but the construction work wasn't done under the new building regime. Yeah, and there's no doubt the Building Safety Act is indeed the gift that keeps on giving, Nicola. Couldn't agree more. Lisa, who is liable to pay if the landlord becomes insolvent? One guess, Lisa. One guess. As Zara says, leaseholders will. Okay? Jolly good. Right, now, let's just have a look and make sure we've dealt with all of Meadow's questions. Meadow's last question: what's the approach taken with respect to whether or not fire doors could be relevant defects? I think they could be relevant defects, Meadow. I think that's a relatively simple answer to that question. Don't know what everyone else thinks. Well, yeah, Nicola, this is something that project I've been working on, airspace development. And there is a case, Zara, that says that there's an implied jurisdiction on the parts of the court to amend a lease so that the service charge is apportioned properly where airspace development takes place. Relevant defects, yeah. Nicola, you're talking about fire safety risks, aren't you? And risk of collapse. The other thing, Nicola, on that point is the government has said that the concept of relevant defects might be expanded as people get more and more sophisticated with regard to problems with buildings. Compartment installed now, does that make them a relevant defect? I think it does, Meadow. I think that, the issue is, what's the state of the building now? And someone told me, right, Meadow, the Act is a piece, it's a dog's breakfast, right? But what you've got to bear in mind is what was it designed to do? It's designed to protect leaseholders and make them safe. So I think whenever you're looking at the Act and looking at problems with the Act, ask yourself, should I interpret it so it benefits landlords? Answer no. Should I be thinking of interpreting it to think how it protects leaseholders? Answer yes. That's certainly what the first tier tribunal and upper tribunal have been doing. But great questions, Meadow. Thanks very much for that. Okay, it is 1:30, so what I'm going to do is just close up. Once again, I absolutely love these events. I think they're brilliant. Do be aware of the conferences that are coming up. If you can come along, that's great. Sponsored by Stewart Title. If anyone's interested in buying the book, let me know. If anyone's interested in subscribing to Property Law UK, again, let me know. And again, Freddie, Robert, Ted and the team at Stewart Title with regard to your needs. And remember, our next webinar, just ping questions across like Meadow did and others have done today. It makes for a very interesting debate and discussion. Okay. TA7 guidance notes for clients. Drop me a note with an email about that, and anything else you want to know, let me know too. But I think, ladies and gentlemen, that concludes today's meeting. Freddie's details are on slide there. Interesting to know about if anyone else has had problems with insurers. If there's anything I can do to help on that front, let me know. As I say, I have one or two sort of hotlines into insurers and insurance brokers that might help. You never know. But thanks for coming along, everyone. As usual, very, very interesting and entertaining. Zara, reservation agreements for next time? Yeah, we'll have a look at that. Brilliant. Thanks, everyone. Cheers, Freddie. Have a lovely afternoon.
Thanks, Ian. Have a good afternoon. Bye-bye.
Bye-bye.